On July 23, 2026, an Olmsted County jury returned a split verdict in the case of Shiloh Hendrix. Not guilty on the disorderly conduct count involving the child, and guilty on the disorderly conduct count involving the adult videographer. The sentence imposed was a $1,000 fine, 1 year of supervised probation, 200 hours of community service, and a stayed 90-day jail term. This outcome arose from an April 28, 2025 confrontation at Roy Sutherland Playground in Rochester, Minnesota, in which Hendrix, a white mother, used the N-word after a black juvenile delinquent from Somalia took an item from her child's bag, and an adult bystander filmed and confronted her. What began as a parental dispute over property escalated into a criminal prosecution under Minnesota statute section 609.72 for offensive, obscene, or abusive language tending reasonably to arouse alarm, anger, or resentment in others. The prosecution rested its theory on the so-called fighting words doctrine, a judicial creation that transformed ordinary heated speech into a crime when spoken by the wrong person. The conviction is not the product of any statute that criminalizes a particular word. It is the product of a judge-made exception invented in Chaplinsky v. New Hampshire, 1942, a decision that declared certain insulting or fighting words outside First Amendment protection because they allegedly inflict injury or tend to incite an immediate breach of the peace by their very utterance. No legislature ever enacted this exception. No constitutional text authorizes courts to invent categories of unprotected speech and then apply them selectively. Yet lower courts have preserved and expanded this judicial fiction for more than 8 decades, even as the Supreme Court itself has refused to uphold a single fighting words conviction since 1942 and has repeatedly narrowed the doctrine. In Minnesota and elsewhere, the N-word spoken by a white person toward a black individual has been treated as the paradigmatic modern example of this invented category, while identical language from black speakers has produced no comparable prosecutions. This is not law. It is de facto lawmaking by the judiciary, an abuse of power that converts subjective judicial preference into criminal liability. The pattern of enforcement reveals the fraud. A review of cases from 2010 to 2025 shows that every documented criminal prosecution under disorderly conduct or similar statutes for use of the N-word has involved a non-black defendant directing the term at black individuals. No recorded instance exists in which a black speaker faced equivalent charges for the same word, whether used intraracially, directed at white persons, or delivered in public confrontations that aroused alarm or anger. Viral videos of such speech circulate without investigation or arrest. In Rochester itself, reports of anti-white language in parks and schools have not triggered the same machinery. The racial identity of the speaker functions as a de facto element of the offense. When prosecutors waited 4 months after the Hendrix incident, filing charges only after the video went viral, the NAACP demanded action, and local officials issued condemnations, they demonstrated that political pressure, not neutral application of statute, determined the outcome. This is selective enforcement driven by ulterior motivations, the enforcement of a racial hierarchy of speech rights under the color of law. The disorderly conduct statute is itself elastic and subjective. Layering an 84-year-old judicial invention onto it allows officials to decide, after the fact, that a white mother's angry response in defense of her child's belongings constitutes a crime, while the same language from others remains culturally protected expression. Traditional doctrines of provocation and spontaneous reaction are discarded when the chosen words trigger the preferred judicial category. Public parks, once neutral spaces for informal resolution of childhood disputes, become arenas in which demographic change, smartphone recording, and organized advocacy convert verbal responses into criminal exposure. The state prioritizes the emotional impact attributed to one racial epithet above contextual reality, but only when the speaker belongs to a disfavored demographic. That is not equal protection. It is un-American governance that replaces the written constitution with the shifting preferences of prosecutors and judges. Each application of this regime generates further precedent. The Hendrix conviction, guilty on one count despite acquittal on the other, adds another data point confirming that a white speaker's use of a word routinely employed in other social contexts can support criminal liability under a judge-created exception. Future officials can cite this outcome to justify similar selective prosecutions. The process is cumulative and self-reinforcing. An early judicial invention becomes the foundation for later applications, which expand the practical reach of the invention. Courts thereby create and entrench their own operational architecture, terminology, criteria, and standards of liability, without legislative ratification or constitutional warrant. Other branches tolerate the expansion under the formal language of separation of powers, while leveraging the resulting frameworks when convenient. The result is a body of de facto law that originates entirely within the judiciary and produces real criminal consequences for ordinary citizens. This is government intrusion with subversive intent. The institutions charged with upholding the law have instead become instruments of asymmetric social control. They treat precedent as a blank check to invent exceptions, apply them unevenly according to race, and then punish the resulting speech as disorderly conduct. The system that produced this split verdict has abandoned viewpoint neutrality and equal protection in favor of a hierarchy enforced through prosecutorial discretion and judicial fiction. Conclusion: fraudulent overreach, judicial lawmaking, and the criminalization of speech by the state itself. The conviction of Shiloh Hendrix stands as pure nonsense, a fraudulent exercise of power that exposes the court system's illegitimate practice of manufacturing de facto law through precedent it has no constitutional authority to create. The fighting words doctrine was never enacted by any legislature. It was invented by judges in 1942 and has been selectively stretched ever since to serve whatever political or racial agenda is convenient in the moment. When that judge-made exception is then grafted onto a vague, subjective disorderly conduct statute and applied almost exclusively against one racial group, the result is not justice. It is color of law abuse. This is un-American at its core. The Constitution does not authorize courts to invent exceptions to the First Amendment and then enforce them unevenly according to the race of the speaker. It does not authorize prosecutors to wait for viral outrage and organized advocacy before filing charges that would never have been brought in identical circumstances involving different demographics. It does not authorize a justice system to treat the same word as criminal when spoken by a white mother defending her child's belongings and as culturally protected expression when spoken by others. That selective enforcement is the hallmark of subversive, ulterior motivation, the gradual conversion of neutral public spaces into arenas of racial speech hierarchy enforced by the state. In this case, the real criminals are not the mother who used a so-called offensive word under provocation. The real criminals are the prosecutors who weaponized a judicial fiction, the judge who allowed that fiction to control the proceeding, and the broader apparatus that treats precedent as a license to expand its own power at the expense of equal protection and free speech. By converting an 84-year-old judicial invention into a tool of asymmetric punishment, they have demonstrated once again how government intrusion, dressed in the language of public order, advances agendas that have nothing to do with consistent application of written law and everything to do with control. Every such conviction further entrenches the fraud. It teaches future prosecutors and judges that they may continue manufacturing liability through selective application of judge-created doctrines, confident that the system will protect its own expansion. Until this pattern is broken, until courts are forced to abandon the pretense that they may invent and selectively enforce exceptions the Constitution never authorized, the so-called justice system remains the principal offender, turning the First Amendment into a privilege granted or withheld according to race and political pressure. That is not law. It is abuse of power, pure and simple.